Hello, my name is Andrew Kinney. I'm the senior Social Security attorney at Hoglund Law Offices in Roseville, Minnesota. I started doing this work in 1992. I help about 500 people or more per year with their Social Security hearings. Today, I'm going to talk about what I tell clients before their hearings. It's 7 different main things. Keep in mind, though, that the information I'm telling you is general. If you want personalized legal advice, don't ask in the comment area personal information. You can contact our offices for help beyond this general information. So in other words, get your own legal help for your particular situation. Um, Hearings are the important part of a Social Security claim. The first 2 decisions, the application and reconsideration decisions, are on paper. There's no interaction, and people who never met you, physicians and psychologists, evaluate whether you can work or not without ever talking with you. So the hearing is an opportunity to be able to talk about what's wrong with you. It's an opportunity to be able to share what a day's like for you. It's also important to keep in mind that your descriptions of what's wrong are most important. There's no formula here. You know how you are dealing with the medical problems that keep you from working. That's what the hearing is primarily about. So here are 7 things I explain to my clients before their hearings, and here are the categories ahead of time. First, preparation. 2, hearing format. 3, how long is the hearing? 4, who is at the hearing? 5, what is the order of the hearing? 6, the job expert's role, what is it? And then 7, closing argument. So I'll go to first, preparation. Uh, Before my hearings, and I'm in hearings all day, I talk with my clients about the format of the hearing, what to expect. I talk with my clients about possible questions they might have. I also talk to my clients and confirm what I'm looking at in medical records. Sometimes medical uh, treatment notes aren't clear about how uh, different problems impact my clients. So even though a doctor might say certain things about severity, that doesn't necessarily line up with how you feel about how severe a problem is. In any event, uh, the preparation, I'll do another video on that, but in preparing for the hearing, the idea is being aware that you aren't being tested, you're being asked in your own words about what's wrong. It's important to check with your law firm that all records are in. You can even offer to call a few sources if there's some that aren't responding. Call them yourself before the hearing. Occasionally we get opinions from treating providers. That's helpful too. Any event, preparation for the hearing is important. I also tell my clients that I don't want them typing out or listing out any detail about what they're going to say. More important is that you listen to the questions in the hearing and you certainly can answer them. It's pretty rare when someone has a problem where they don't understand how often something happens, like perhaps seizures or things like that. For the most part, you are not trying to say a statement. You're trying to be a person in this hearing and convey that you're speaking directly about what's wrong with you, and that's important. Um, Second area, hearing format. The hearings are either in phone, by video, or in person. In person was the standard before COVID. It is pretty rare now. It's possible. Generally, though, the hearings can be done by phone, which is the easiest. Video format works. It has a little more involvement getting things ready. Not too bad. And so with the phone hearing, Social Security calls you, calls the attorney, calls the other people involved in the hearing ahead of the hearing. Your conference called in, and you can talk to the judge by phone. The video format, the way that is set up is Social Security sends an email with the link. Make sure on the device you're using you install Microsoft Teams, and that's the video app Social Security uses. And then I tell my clients about 10 minutes before the hearing, click the link, it opens up Microsoft Teams, or should, and then within Microsoft Teams, click join the meeting, and then you're in a virtual waiting room until the hearing starts. If you are waiting in this virtual waiting room 15 minutes or more, you'll usually get cut off. You would just click the email link again to get back up. And I also tell my clients that if there's a problem with the video format, bandwidth issues, whatever, that we can plan to shift to phone format so it doesn't cause a delay in the hearing if possible. Um, 3, how long is the hearing? Hearings are generally about 45 minutes. Some judges are quicker, and some judges take more time. They can be maybe up to an hour. The idea here is that hearings are different based on essentially what's going on in the hearing. Some people have a lot of different medical problems. It takes longer to discuss them, so naturally the hearing will be a little longer. Other hearings have different legal issues. Some of these legal issues can be resolved fairly quickly. That might be a brief hearing. But in any event, plan to have an hour set aside where no one's in your room while you have the hearing if you're doing by video or phone. 4th, who is at the hearing? It's the judge, you, and then the attorney if you have one. There's always a job expert for people 18 and older. And occasionally there's a medical expert. If the judge has brought one in, the medical expert will speak to what the medical records say. They may ask you a few questions, but generally it's a commentary on what the medical treatment notes say. The job expert, on the other hand, will discuss your past kind of work, whatever it is, in the last 5 years, and will answer questions at the end of the hearing. 5, what is the order of the hearing? Well, the way I help my clients understand this is the hearing starts, the judge will verify you are who you are, so your social security number, usually address, other identifying information. Then the judge will usually have the hearing assistant go on the record or record the hearing, and that's a good thing. Then the judge will verify that you're not recording, that you're alone, usually. Then the judge will talk with the attorney about the state of the medical record. Is everything in? Is anything pending? The judge will also talk to the attorney about any other procedural matters, if there are any, with the case. There's usually at that point, there may be an opening statement by the attorney discussing issues or pointing out page numbers of where things are in the medical record. After that, the judge usually asks you questions. First, basic questions about where you live, what kind of place you live in, things like that. And then about physical or mental problems, either, both, and ask about your ability to do things day to day and how you're limited from them. Then the judge will turn the hearing over usually to the attorney, who will follow up with questions, not repeat them, usually follow up, maybe getting more detail and getting examples of things that, for instance, a hobby that you can no longer do, things like that. And number 6, in terms of what I tell people about their Social Security hearings, I talk about the job experts. The job experts then talk. The judge will shift to the job expert. Usually the attorney and the judge will only talk to the job expert when you have an attorney. The job expert will go through what your past work is recently within the last few months of this video recording. Social Security only looks back 5 years. The judge will ask the job expert the kind of past work you used to do, and they will define it under how Social Security defines it. They have codes under what's called the Dictionary of Occupational Titles. Then the judge will ask questions of the job expert. This is the key part of the hearing. The questions for the job expert would be called hypothetical questions. If a person had a certain number of medical limitations, are there jobs that this person could do? It's talking about you, but it's speaking generally. Some questions allow for jobs, some don't. The job expert does not decide the hearing, but the job expert is offering evidence for the judge to make a decision. The judge will make his or her decision after the hearing. It comes in writing. It usually takes at least 2 months, sometimes longer, depending on the hearing office and how caught up they are. In the final part of the Social Security hearing, once the job expert speaks and your attorney, if there are other questions, the judge will allow the attorney to ask the job expert questions. The attorney might have closing argument, a summary of the evidence, or at least information that might help the judge make a decision. In these Social Security hearings, the job expert testimony may be different, and depending on what the testimony is, the closing argument would address maybe new things that came up. particulars like handling objects or reaching forward or things like that. Uh, but the argument is that you're unable to work any full-time job. There are details there, but in essence, we're saying that you are currently not working too much and you cannot work anymore or can't work at all because of these medical problems. Okay, that's all for now. In my next video, I'll talk more about what you will be asked at your Social Security hearing. Again, this is Attorney Andrew Kinney from Hoglund Law Offices. Thank you.